simple type of thing?
It's Jason, the other one's Jonathan, but there's no Alicia. I don't know if it's just something she left out. Or,
Did you find that?
Professor Fogg, can I just ask you a question? On this packet you gave us, at the back, there's like, the court, the Commonwealth, I don't know what you want to call it, petition, I guess, that they're gonna come back on August 10th. There's one for Jonathan and one for.
Yeah, I just didn't have a copy of the other one.
Okay, but
when I
there's,
did.
Alicia's is missing,
It
but
would
we're
have been
to
all three.
assume
Yeah,
hers
it would have been all
the
three.
same.
Yeah, they're all
Okay,
the
thank
same.
you.
Okay, so not all the, a couple of attorneys have not come in yet, but I want to get started. I'm the mediator that the court has appointed in the Cameron protection case. And while I've got other parties here, where ultimately I need to be able to go back to the court, to the judge in the Cameron protection case, and make some sort of report as to any possible stipulations, any possible settlements, not only in regards to care protection, but to the possible criminal prosecution of the father in this case. Do you want to go off the record for a second? Because I'm going to ask for identification.
Just wanted to clarify the
Yeah.
question. So you're making a report back to the court then, so what occurs in mediation is not confidential for this session, or?
My report will merely consist of, it will be confidential, because my report will be, there's gonna be a stipulation in the CMP as to this, and the DA has agreed to such and such, or there's no agreement. And we need to move forward on all of the cases, so it is confidential, okay?
I have a question.
So,
What role
yeah.
are you playing?
I'm the mediator in the
Okay.
Cameron protection case, okay? So again, I'll call this the mediator in the Cameron protection case. I want to just, if you could just briefly go around the room, and when, I know that some attorneys are co-counsel together. If perhaps, one person for the group could identify not only what role they represent, but also just generally what your purpose is, what your strategy is relative to this mediation. What is it that you want, whether you're the DA, the department, children's attorneys, and so forth. So I'm going to go around the room. Whoever wants to go first, just identify who you are, which is.
Karen Applebaum, and I'm the Commonwealth. We are the district attorney, and these are my two associates. And we are here because we feel that there is an issue that the father should be, we're hoping that we indict him. We feel that he has committed a crime. And although we know that there are more facts to this case than just what we allege he has done, we feel that we have a very strong position that this man should be indicted.
Okay. Next.
Good afternoon. I'm Karen Petrie. I represent me along with my co-counsel, Sandy Alisea and Amy Carminello. And our position is
You've been appointed in the Cameron protection case?
we're in the care and protection case on also his criminal record.
Okay, all three are on both?
Correct.
Okay, it isn't as if one's going to be speaking to one and one another. You're all jointly going to be
Correct.
speaking to both of the cases. Okay.
Correct.
All right, thanks.
Yes.
All right. Next.
Hello, good afternoon. My name is Jamie Krasansky, and this is Geneva Panopoulos, and we are attorneys representing the DCF. seeking permanent custody of the children.
Okay, thank you. Next.
This is Maria Gomez, and I'm here representing the child, Jason, together with my co-counsels.
Omar Farouk, Debbie Walker.
And we are actually seeking to represent his wishes of returning to his father. So reunification is the goal.
Thank you. Next.
Hello, Elaine Mitchell, counsel on behalf of Alicia, and we have co-counsel.
And who's Alicia?
The juvenile,
The juvenile?
12-year-old girl.
Oh,
Amanda Suleiman.
Leslie Arsenault, we're the attorneys for Alicia, the 12-year-old daughter of defendant.
okay. Next. Mark?
I'm Mark Fournier. I'm the court-appointed investigator, and I'm seeking reunification of the family after the father has substantial therapy and the children individually as a group have therapy, and to review the situation in 3 months.
Thank you. I'd like a summary first from the department. Summary of the case, just to sort of set things in context first.
Okay, well, starting out, we received a report, and a police officer and a social worker went to the home of Alicia and Jason because they were responding to the arrest of their father, Lee, when there was an accusation by the neighbor that he had been sexually abusing the neighbor, Justin. So when the police officer and the worker showed up, they interviewed Jason first because Alicia took the younger child outside, and he did not say anything regarding his father abusing him. However, when the children switched places and Alicia came inside, she did admit that she had been sexually abused and that her brother Jason had also been sexually abused. So then they called Jason back into the room, and he did finally admit that he had been sexually abused. So we took the children, because we also got a phone call that the father was being released on bail. So we took the children, and we informed the father that they were going to be held until an emergency hearing took place. And they were placed temporarily, one or two of them with the uncle, and then one with the maternal grandmother. And so, that brings us to this care protection case.
And the department has custody? How did the department get custody?
The order of the court, they gave us custody, temporary custody, and we're seeking permanent custody. Yes.
For the district attorneys, either Kate, Karen, A, or Joe, might answer this. Now, the department just said that the father had been, quote, released on bail. And rather than question them about what that case is about, maybe one of you could summarize that for me first.
The father, Mr. Lee, was arrested on, I believe, 4/21/87 for sexual assault of a young child named Justin. Who revealed that while he would visit his friend Jason, that Jason's father, Mr. Lee, would sexually assault him. And upon information from that, he was charged.
So the Commonwealth has indicted Lee for the alleged sexual assault, with the victim being Justin. But at the beginning, Karen A mentioned that the Commonwealth District Attorney's Office is thinking about indicting Lee relative to the possible abuse of his children?
Yes, based on a referral from DSS in this case, we are.
What do you mean by that?
The DSS informed us that they had information that he also abused his younger son as well,
How did DCF inform you about that?
via a referral.
What do you mean by that?
Yeah, no, it's 51A, but no, it's a call when they notify the DA.
Hello?
A referral to the DA, right?
What specific information do you have, does the district attorney's office have?
We have the police report, as well as a copy of DCF's 51A.
Okay, 51A and 51B.
Yes.
And that's all you,
We have the investigator's report as well.
what do you mean by that? The 51B?
Right.
The 51B?
Which is part of it. And we
The
also-
51B.
Right, and we also have another additional witness who is the first case. He witnessed, this child witnessed the father leave.
Hold off on talking about whether Justin is an additional would be a witness in the case against Lee. I will get to that conversation shortly. Karen, Keith represents Lee, Sandy, and Amy. What is your position in terms of both the Karen protection and the criminal case?
Can I ask a clarifying question
Yeah.
of the DA? My understanding was that our client was released on his own recognizance, that there wasn't any bail set or
No,
anything.
you're right.
That was my understanding.
Okay, that's
Okay.
correct.
Yeah.
So I just wanted to have that.
Okay, and again, just to clarify, the point that I think that the DA's clarified, so far, there are only 2 open cases. Karen protection of Alicia, Jason, and Jonathan, and then Commonwealth versus Lee, but just the case regarding Justin. And the district attorney's office is currently investigating, collecting information from DCF and thinking about indicting your client relative to his children as well, right? Okay, so can I hear from any of you 3 that represent Lee, any beginning summary that you want to make relative to either of the Karen protection or the criminal?
Sure, I'll speak to the care and protection first.
Okay.
At this point in time, the children are in the temporary custody of the department. My understanding here today is the department is going to seek permanent custody. The position of our client is that he would very much like to be reunified with his children. At this point in time, based on the reports that everybody has in front of them, our client, with the exception of the current allegations that are being discussed, has been a fantastic parent. His children are fed, they are clothed, they go to school, they haven't been absent, they're good students. There have been no prior 51As. There were no concerns from the school personnel that were interviewed, and so there were no other concerns on the table. So at this point in time, it's our position that the department would not make their burden of clear and convincing in order to be able to receive permanent custody. And our client very much wants to be reunified with his children, and in fact has said so, let the court investigator know, has let everybody know. He's been completely cooperative with the department. He attends visits. He contacts his children only as directed by the department. He's willing to do evaluations and therapy and treatment. So we have a very willing parent here who would like to be reunified. So it is certainly our position and our client's position that that's what he would like to see happen. That there be, we continue on a plan, as is the department's mandate, towards family reunification at this point.
Now, do either Sandy or Amy, do you want to summarize in regards to the criminal allegations?
Yes, we don't have enough information in terms of the criminal. We don't have really any information regarding what Justin has claimed against the father, and we've advised him not to speak to any therapists or anything at this point, because anything that he says to any kind of therapist is gonna be used against him, so that would be, you know, it would be wrong at this point. I don't feel that we have anything to negotiate at this point on a mediation with, I mean, there's so many discrepancies in all the reports. The police report, the social workers report, the court-appointed investigator, there's so many discrepancies from the beginning to the end that we have no idea at this point what truly happened. I think there's quite a bit of holes at this point. And-
Sandy, did you have anything to add?
I agree with my counsel. We need more information at this point. There's nothing there for us to base where we wanna go and what we wanna do.
I'll come back because there are specific sort of evidentiary issues that will be coming up both in the criminal and the care and protection case, but I sort of want to hear from everybody first, and I'm going to jump to Alicia's attorneys next. Alicia's attorneys?
Yes, Your Honor, I'm Leslie Astronaut, and I'm one of Alicia's attorneys. As her attorneys, our job is to advocate for not only what's best for Alicia, but what she wants. And at this point in time, Alicia wants to be reunited with her father, provided that he stop his sexual abuse.
That's not your position.
Okay.
Stop at reunited with the father.
Alicia wants to be reunited with her family.
Okay. Jason's attorneys?
Ed Walker for Jason. Jason as well wants to be reunited with his father. That's his wishes, and that's what we're here to advocate for today.
Ed, could you speak a little bit louder?
Jason wants to be reunited with his father, and that's what we're here to advocate today for him.
Jonathan's attorney is not here. That would be Abby. Jonathan is the agent. Let me hear from the court-appointed investigator, Mark, who's going to summarize your report and your recommendations, and then Tanya is the GAL, and we'll hear from her too.
Okay, Mark Fournier again. The conflicting testimony from.
Well, you don't have testimony yet.
Okay.
You went and investigated the
Yeah.
facts. I understand you spoke with Ellen, the social worker, and Kathy, the police woman, as
officer.
well as others. So.
And I obtained information summaries from each of them, and again from the children, and there seem to be many inconsistencies. The children appear to have recanted their testimonies if it was in fact.
There's no testimony, let's be clear about that. There's no testimony. The
They
court has,
well, they
in
recanted their
fact,
story,
he
is a
has
better way to say it?
waived the 72-hour hearing. So there's been no testimony in court
Okay.
anywhere.
So I should, instead of using testimony, I should say their statements.
Statements, absolutely, okay.
Okay, so they recanted their statements. The children seem to be in no fear of the father. They want, in fact, to be back with their father. They are excelling in school, both honor students, and they're well liked by their peers and their instructors and principal. It seems to be unusual in such a case that they are so well adjusted, and I recommend that the father, who appears not to have any memories of a lot of this, actually seek counseling because of his medical issues and his grief with his wife being killed in a car accident, and the children to seek counseling for the same thing, for their loss of the mother and for what's recently been occurring, so that they all can get the therapy they want and then be reunited rather than being separated and living in foster homes, which is not always the best thing either.
Tanya, the GAL.
Yes, so because my concern is really the children, so I had statement from each children separately, and they seem fine, they seem okay as regular children, and the statement from the school also, so they're doing well, and they look like regular student, and their grade is well, they're like well on, they're doing really well in school. But the concern is still there because sometimes even if anything doesn't show at the time, but maybe in the future, something might show up that was based on their past. So therefore, I strongly suggest that they continue with the therapy. But in terms of getting back to the father, so I'm definitely want the kids to stay together, but being back with the father, I think we have to
So what is the best interest of the children right now, and since you mentioned the future, and in the future as you perceive
They
it?
need to be very persistent, continue on getting therapy and counseling to make sure that if they excel in school right now, in the future they don't turn to be, the situation doesn't reverse based on whatever they were doing.
Okay. What's your position about the children possibly having to testify in a protection case?
I'm a little concerned about that because I don't know how ready they are to do it, because it seems like they still have good, strong feeling for their dad, and they really basically respect him and want him to do well. So this may have some negative impact on them, unfortunately. But at this point, it might have been necessary that they have to testify to let them know, because they are in that situation. They have to let them know what's going on, and they are dealing.
Can I ask Alicia and Jason's attorney, I'm imagining that your position is that your clients are not going to testify at the care and protection hearing.
Jason will not be testifying.
Okay, and
Jason,
Alicia will not be testifying,
Will not
correct?
be testifying.
Okay. So, and now, so here's a question for the department in terms of, one of the reasons why the court asked me so early on to see if we can mediate this has to do, well, really with a lot of factors. One factor being the possibility that when and if the case goes to trial, there just might not be enough evidence that amounts to clear and convincing evidence of Lee's unfitness. Taking that along with the court-appointed investigators, summary regarding the relationship the father has had with his children, how they're doing well in school, et cetera, et cetera. And again, the court has asked me, is there a possibility of some sort of resolution in these cases, understanding that there's the conflict with the criminal prosecution. And obviously, if dad's in jail, then we really can't come to any sort of resolution or statement. But anyway, coming back to if this case goes to trial, how are you going to get in? For example, let's start first with Ellen. Ellen, the social worker. Obviously, what I've heard from not only you but Mark, the investigator, is that both Alicia and Jason, allegedly made some very detailed statements regarding, Lee having sexually abused them. So if you get Ellen on the stand, can you get Ellen on the stand to testify about those statements? Jamie's saying yes.
Yes.
Yeah, you can?
It's considered a fresh complaint, and that.
I'm sorry, I didn't hear you.
A fresh complaint, that likely the statements will be able to come in as a way to corroborate what the children had been already saying, and the children didn't recant their entire statement that they had made. They recanted some details that they may have forgotten that they.
So let me ask you this with regard to fresh or first complaint, as it's now called. I mean, what law do you have behind you? If there's going to be an objection at trial, how are you going to make an argument that Ellen and/or Kathy's? And again, I'm using their first names because if I keep saying police, social worker, Ellen is the social worker, Kathy's the policewoman, right? So how are you going to, if the other side, be they the children's attorneys or Lee's attorney, stands up to object, what will your legal argument be to the judge? Well, judge, it should come in according to what?
Is it section 83?
Well, hold off about the statutory, and we'll come back to that relative to Jason's statements, the statutory exception. But you gave me a different legal standard, and if you could articulate what fresh, how would it come in under fresh or first complaint? And, is there a case law or
in custody of Tracy, they felt that secondary hearsay in an investigator's report was
No, not the investigator's report. Again, imagine a trial, you've got either Ellen or Kathy on the stand.
Mm-hmm.
And the minute that, Kathy, for example, says, I spoke to Jason and he said, blah, blah, blah. Lee's attorney's going to be on her feet immediately, objection, that's hearsay. You're gonna say, according to what you just said to me, no, it's not, Your Honor, it's fresh or first complaint. So tell me how it is.
Because it's coming from someone who was the first person that they complained to. The police officer and Ellen were the first people to respond. So they were at the scene, and that is the first time the complaint came out that their father had abused them.
Okay, again, what case or cases would support that theory? Jamie?
In Reed custody of Jennifer.
Okay.
We discussed that it's not hearsay if the person testifying is saying that the victim came directly to them, and that testimony corroborates the victim's evidence, and it can be shown to display abuse.
Okay, let me, and I know there's probably counter arguments to that, so let me hear from either Lee's or any of the children's attorneys relative to, how would you argue, again, at trial, that those statements shouldn't come in under fresh or first complaint? Again, either Alicia's attorney, Jason's attorney, Lee's attorney, any of you can answer that. Amy represents Lee.
Amy Carpinello representing Lee. In regards to the victim actually coming forward and saying all the statements, these statements that were all reported in the reports were all done with leading questions by the children.
Well, but leading questions is, and I'll let you make that argument,
No.
but isn't that a whole other issue? I mean, if the purpose of the, and again, I mean, you might successfully make that argument, but if the purpose of the testimony, as DCF is saying, if they're gonna be saying to the judge, well, Your Honor, this is fresh or first complaint, that's different from the questioning was wrong. Do you know what I'm saying?
Yep.
So I'll hear you on the leading questions, but not right now.
Okay. All right, because
So,
okay.
how would you argue that it's not first or fresh complaint? I mean, would you concede it at that point?
No, they didn't go to I mean, these people came to them. I mean, they did not admit it. In fact, Jason did not say anything until he was questioned the second and third time. I mean, he clearly denied it.
But for example, in the Amaral cases, the nursery cases, you had over the course of like 15 months or more, kids making statements to their parents, to their doctors, back and forth. All of these statements qualified as back then it was called fresh complaint. So that it's not that it's such a loose standard, but isn't it as long as the person on the stand has been complained to by the victim?
Yep.
So if I'm the judge, is that the way, I mean, you guys don't want that to happen, right? These attorneys or the children's attorneys. Because if that's the case, that means the judge is gonna hear all of this damaging testimony. Ellen's gonna go on and on and on. Which one, I think one, Geneva, did Ellen, which one talked more with Alicia and which one talked more with Jason?
Well, yeah.
They sort of both did, but one took more of a role.
Well, Ellen did because
Right.
the police officer left because Jason didn't feel comfortable talking in front of all of them.
Ellen talked more with Jason.
Yeah.
Who talked with Alicia?
Also Ellen, but the police officer was still there writing
Okay.
down the report.
Yeah, what, is somebody, Karen is looking physical?
Well,
I don't know if that even matters, but I just wanted to know the clarification.
I understand that, these are according to the information provided, that these are the first statements of the children to professionals. However, I don't see how that would come in for the truth of the matter where the children are not going to be testifying.
All right, okay, so I've heard from, and by the way, Tanya, that is your position too, even though you didn't say it. I've heard from the GAL and children's attorneys that they won't be testifying. So the issue that I have, Geneva and Jamie, as DCF attorneys, that if you're gonna attempt to put Ellen or Kathy on the stand, and immediately upon one of them saying, he said, she said, there's an objection. If you try to argue that it's first or fresh complaint testimony, the judge is gonna say, you know, are you gonna call the children? Well, yeah, you'll say you're gonna call the children, but immediately you're gonna get objections from the children's attorneys and the GAL that because of whatever reason, and they may or may not be asked for their reasons, they're not gonna testify, so therefore.
Well, are we bringing in statute now?
What?
Are we bringing in statute now?
No. No, just one at a time. You might be able to get away with it under 233, you know, in terms of Jason's statements, but for now, so I just want to take it piece by piece. So that's one of the evidentiary questions that, on its face, it looks like, well, you have 2 investigators. It looks like it's fresh complaint. But if the children aren't going to testify, there's no cooperation. And normally when you have a rape victim, for example, and you have police, they're testifying. But as Karen said, it's not for the truth of the matter. They're only testifying as to the report that was made to them. And then the victim testifies. So let's put that aside for now, because it looks like that's not going to fly. All right? Now, you still have the out-of-court statements, and I know you want to argue the statute, but let's do that last, because the statute only applies to Jason. So you have the out-of-court statements of Jason and Alicia. Is there some hearsay exception that the department might be able to get the statements in under?
It could go to state of mind of the child that is substantive, that we wouldn't be using it just to prove that he actually did sexually abuse them. We would be using it as their state of mind, and that they're likely, when they said it, they didn't have a reason to lie, and thus it can be reliable.
Okay, so if you're able to offer at least, maybe not all, some of the statements, and you're clear to the judge that they're coming in only for state of mind, then there really can be no objection or argument, right? The children's attorneys, leads attorneys, if truly they're coming in for state of mind.
And we'd certainly have it on the record, however, though, that it was clearly state of mind and not for the truth of the matter.
That's right. So, I mean, that would be the stipulation there.
Right, but I think we still have a strong case considering the fact that we'd be able to offer the own party's statement against him.
That's another one, okay? We'll get to that.
Okay.
Declaration against it. So anyway, state of mind, it looks like you can get them in for state of mind and state of mind only, okay? So let's move to, okay, so go ahead. So you're gonna offer, like, for example, what?
For which one? For the children?
If you're saying that you're gonna offer the children's statements, remember the Sophie
As to
case?
state of mind.
Or were you talking about, not state of mind, you just said declaration against interest, admission of a party opponent. Is that what you were getting
Yeah,
at
I
for
was
your
getting
next
that when
point?
we did report to Lee that we had custody of his, temporary custody of his children, and we asked to speak with him and for him to come in, and he did admit that
He
had.
said something.
Yeah.
Okay, so that something can come in
Yeah.
relative to Lee.
He admitted to sexual abuse.
Well, he didn't really admit the sexual
He
abuse.
didn't go
made
into
some
detail,
statements.
but he said that something
Had happened.
Okay. So Karen, Amy, or Sandy, the statements of Lee to Ellen, according to DCF, they're saying can come in as statements of party opponent.
Well, clearly the statements of what our client said about the children undressing, that's obviously statements that he made to the social worker. However, it is certainly not clear from the social worker's dictation that when he made references to sexual abuse, that he was admitting to what the department is alleging that the children have said. So it is not clear
Right,
at
and
all.
it would, and again, at trial, it would have to be clear that Ellen needs to be able to testify that Lee told me that X, Y, and Z. And then if you make objection, again, if they're offering it, it's truly the statements of Lee that are against his interest, then they would come in. But my point before was it's just Lee. The children's statements cannot come in that way, and that's the Sophie case, remember? That was like a week ago.
Yeah.
It wasn't in the child sexual abuse packet, right? So that should, you can pretty much throw out almost everything at this point, because they can't come in just to sort of review. Can't come in as fresh complaint, looks like. Only these statements can come in as to admission. Can come in, but only a state of mind. You'd be successful on that. Is there another hearsay exception?
I would also say that her observations could come
Who's
in.
her?
Ellen. Her observations would be able to come in, and some of
For
them.
example, the anatomically correct
Yes.
dolls. Again, but you have to be careful that it's not coming in and looking like it's hearsay, right? Well, is there another hearsay exception as to anything that the children might have said? I'll help you out a little bit. What about I hate him and he's a child molester or something to that effect? So possibly, and again, it's not going to be everything Alicia told Ellen.
Present sense impression.
Yeah, some sort of spontaneous, excited utterance, present sense
Objection, taken out of context.
But it's only going to be that quote. It's not going to be everything that Alicia told Ellen.
No.
Right?
It won't be everything, but I don't think we need everything to prove the fact that the children don't belong in the house anymore.
Court-appointed investigator. He's going to be your witness as well.
Mm-hmm.
So you started to mention him before. How can you use him again, sort of in the scope of things, sort of in the totality, to be able to prove clear and convincing evidence of his unfitness?
Well, you could bring in his report,
He's
and
going to
then.
be on the stand as well, subject to direct and cross-examination. So when Mark then starts to say, Ellen told me that Alicia told her, right?
Yeah, that's.
And there'll be an objection.
Mhm.
Are you going to be able to get that in?
Yes.
And tell me why.
Custody of Tracy.
Right, really want to use that Tracy case, right?
Holiness secondary hearsay and investigator's report is admissible.
And tell me why, in terms of his sources, and maybe Mark can help out on that as well, as he's a court-appointed investigator and an attorney. Why are you going to be able, Mark, to testify, Ellen told me that Alicia blah, blah, blah. Kathy told me that Jason blah, blah, blah said. So totem pole hearsay, double hearsay. Why is that going to end up being admissible?
Because the report I'm making is based on evidence that I'm gathering, so it's a report, which is an exception to hearsay.
Yeah, how is it an exception in the context of a care and protection case?
Well, records normally kept in the course of business.
Well, it isn't really a business exception.
Okay.
It has been held, as in cases like Tracy, which Geneva loves so much, that the investigator's report is going to come in. But doesn't always all of it come in. Tell me something about your sources, though. So when you say Ellen said,
Is Ellen subject to cross?
Ellen's here. You can identify her source. You're not saying someone told me or you know, one of the teachers said. So chances are, so far, it looks like the department has, for a case, getting in statements, but only for state of mind, getting in these, you know, specific statement to Ellen is a declaration against interest. Statement of declaration against interest. Maybe a spontaneous utterance or two that Alicia or Jason might have made. And then the investigator. Is this going to be enough? And that's it. I mean, that's going to be your evidence at trial. You're going to call the children, they're not going to testify. They can't be forced to testify. You're going to call Lee. Is Lee going to testify? Is your client going to testify in the care protection case?
No.
Now.
Justin's coming, if he does
No,
the case.
we have advised our client that he should not be testifying.
Now, and I would, and you know, if Lee was my client, I would do the same thing. However, the court can also, in the care and protection case, draw a negative inference of unfitness. But again, and I'm going back to the department, I still see, you know, and I know you want to get to Jason and the statute, and we'll get to that too. But so far, I'm seeing in the care and protection case that the department might lose. And again, that's part of the reason why I've been ordered to try and mediate. Now, I heard something about Justin, and let me just clarify something that some of you are not going to like. The victim witness office, in fact, the lawyers don't even know this yet, has reported that Justin, and his parents have actually moved. And yeah, this really happened. You can't make this blankety blank up. It really happened. Justin and his family have moved. They want nothing to do with either the care. In fact, the department was thinking of actually calling, you know, Justin in a care protection case as well, and that might have helped you. But he's not. Obviously, that's a big deal for the DAs, because now that criminal case that is ongoing is going to have to close, because you've lost your victim. He's gone. They're out of the jurisdiction. They've left. Huh? I think he was around the same age as Justin, so he was around 10-ish. Like that. Huh? Oh, well, who?
Justin.
We're not going to deal with Justin's out-of-court statement.
Well, would it?
Jason was 11 and
He's
the other
unavailable.
was
He's
16.
unavailable.
He's unavailable.
So you can now.
But this is the point, that we don't have an open criminal case. But the Commonwealth is still thinking about it. We've got plenty of information regarding Lee's own children. And that's the reason why, you know, the possibility that we might be able to settle both of those cases, you know, with whatever, services, therapy, etc., and try and keep this family together if there's the possibility. So Justin is gone, so that indictment is going to go away. That case is going to end up getting closed by the Commonwealth. But the Commonwealth still has a strong argument that they're going to be indicting Lee relative to the information that Lee has sexually abused his own children. Okay. Now, you're also faced, as the Commonwealth, with the same sort of holes, but in a different way that the department has. What is your evidence going to be? And now we can get to Jason, all right? So Jason is under 10. You've got some statements of Jason. As the Commonwealth, how are you going to procedurally go about getting Jason's statements in?
We have a hearsay exception for a child under 10 who is unavailable, and if he's somehow...
If you could just cite the statute, any of
It's 233-81.
233-81, okay, so what do you have to do if that's going to be what you're, the next step that you'll take after you indict Lee, of course, you haven't indicted him yet.
We have to show that he's unavailable, and then we're allowed to have any statements that he made through to other people entered into evidence.
So you're gonna let the defendant know, and the court in the Superior Court, judge, will hold a 233-81 pre-trial hearing to determine if those statements should come in. Are they gonna come in? What's your argument? So you use the statutory factors if you would, or whatever argument you have.
I believe that
So Jason's statements, mainly to Ellen, right?
statements to Ellen are going to come in because he was under 10 years of age.
Can I just ask, how was Jason unavailable?
Due to his emotional.
Expert testimony.
So, the court finds, based upon expert testimony of blah, 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 the testifying will be likely to cause severe psychological and emotional harm as a child. So I'm assuming that's your GAL, Tanya, who's an expert. And she's already indicated that she believes it's not in the best interest of children to be testifying in either the care protection or the criminal case. So is that how you're arguing that Jason's gonna be unavailable? Do I, any arguments against that? I saw Leslie's hand was up before, I think, Elizabeth.
But I just have a question, I don't know if I should do it now or.
A question about this
About
particular
the,
Jason and the
about
statute?
the whole, like, if the statement is gonna be admissible, or if the kids are gonna be able to testify, I don't know, it's just, it's about the Saints, interview. When they do that interview.
So when they did that in this case, by that time, Jason and Alicia, by the time they were taken to, even before the Saint interview, by the time they were taken out of the home and in the offices of DCF, they were immediately recanting. So they didn't say anything at the Saint interview.
No.
No. So the only statements that we have that are damaging are the statements they made at their home to Ellen and Kathy. Geneva?
But we're also going to bring in probably expert testimony that speaks to the fact that a lot of children recant because of guilt and feeling bad and separation anxiety from their parents.
Okay, good point. All right.
You know, we will certainly argue that, you know, that's more along the lines of profile evidence. You know,
what would be profile evidence?
Talking about that a majority of the children who are sexually abused recant, you know, in this case.
But isn't that more like syndrome evidence, which is normally okay?
Yeah.
What wouldn't be okay is if somehow there's expert testimony that your client fits some sort of profile, right?
Well, I don't know. I think if they use, well, it depends on how it's presented, I guess.
Okay.
It could be done syndrome, but if it's, you know, well, the children must be recanting because they are sexual abuse victims.
Right. That's
that
right.
would
That's
not
right.
be.
And they can't, according to, and I can't remember which case or cases that you had to read, Geneva.
I'll find it and then I'll let you.
It may be Colin that the expert really can't testify sort of to the ultimate issue.
Yes.
That the
Yes,
children
it was
were in
Colin,
fact
correct.
sexually
Colin
abused.
speaking.
The expert can testify generally that in many cases children do recant. So, let me ask, Geneva brought that up as the department's attorney. So, would an expert be used relative to that issue in the care and protection case and in the criminal case? Would the Commonwealth also be using an expert?
Yes.
Can I just get back to Jason though and the 233-81 pretrial hearing? About
There's a big problem, I'm not on that side, but there is a big problem with the computation clause.
Yeah,
I mean,
yeah.
we have several court decisions since this law was, since 233-81 have gone in, Supreme Court decisions that say that you have to have the right to confront any person who gives testimonial evidence against you, and this would be considered testimonial evidence. We don't know that 233-81 would actually satisfy the Supreme Court standard.
That may be so, and that may be an argument that either Children's or Parents Council might bring up at the trial level. However, the judge at the trial level can't even make that determination. It's possible if that comes up as an issue, that the judge might end up reporting it as a question to either the appeals court or the SJC. If I were the judge, I would just rely on the statute and say, you know what, the statute and the purpose of the statute initially is still the purpose today, carving out an exception for child victims, you know, particularly in not only child sexual abuse cases in general, but cases when, you know, their abuser is a close family member, and that, just like the U.S. Supreme Court case, you know, that talked about, you know, you got to take them on a case-by-case basis, and there's a finding of necessity, and, you know, you've got an expert, for example, the GAL here, who's saying that it's really going to cause severe trauma to the children to testify. But that's a very good argument that can be made and perhaps preserved for appeal, and who knows? Maybe this statute might be found to violate.
The recent Massachusetts evidence guide already points to the fact that this is going to likely be a problem. They said there's no case law in Massachusetts that addresses it at the moment.
Do you all have the proposed rules of evidence? You can just go on mass.gov and pull them down. They're great. We still don't have, you know, in Massachusetts, it's still common law, but the courts greatly rely on proposed rules. The 2012 is out.
The rules now, they're just not, they're not laws.
Right,
It's
exactly.
a guide.
Yeah, they're a guide.
But it's more than the proposed, they actually, SJC has actually approved them, but not the rules.
That's right, yeah. Karen?
I think too, the other issue with getting the statements in under section 81 is that, you know, the care and protection of Martha talked about the independent cooperation of these sort of out-of-court statements, that really is a part of what needs to happen as well. And in this case, there is no independent cooperation, as there, you know, Martha, there was plenty, but there is none. They are simply statements. There is no other evidence available.
So there might be certainly it's going to be much easier for the care and protection judge under section 83, right, to get the statements in. Why is it easier under 83 rather than in the criminal superior court case under 81? And not just what Joe pointed out, but why?
They don't have to be unavailable.
What's that?
They don't have to be unavailable.
Right, what's the standard for care and protection? So if you want to bring Jason's statements in as the department, what do you have to do? What do you have to convince the judge of under section 83?
More probative.
So as a material fact, more probative on the point.
Can you just either read it, Jamie, or say it like really clearly?
Of what the statute says.
Tell me how the judge would be convinced, in the juvenile court judge, to allow you to bring in Jason's statements.
If the judge finds that the statement is offered as evidence of a material fact and is more probative on the point, which is offered than any other evidence which the proponent can procure through reasonable effort.
Okay, all right, so it's likely, I think on its face, from what we know right now, it's likely that Jason's statements will come in under 83 and possibly under 81, even keeping the defendant's, you know, constitutional rights in mind. Let me ask Alicia and Jason's attorneys, this role of counsel sort of issue. You mentioned at the beginning that both of your groups were representing what your clients wanted. And if you could elaborate on what that means and why should that be your position in this case? Anyone of you?
I'm Leslie Arsenault, counsel for Alicia, and I believe that in order for the complaint, for the statements to come in as evidence, they cannot be a result of suggestive and coerciveness. And
That isn't what I was asking. You said that your role is to advocate for Alicia's wishes, and that Alicia wishes to return home. Is there some sort of conflict or issue with that role, this being the type of case that it is? Elaine? Elaine looked like she wanted to say something, that's why I was.
Is it clear and convincing standard?
No, not the standard. It has to do with your role as counsel for a child who's possibly being sexually abused. Maria?
I just think that based on the circumstances of the case, we have a case where the kids have been sexually abused by their father, but at the same time, they claim to have a really good relationship with their dad. And I think that that might be the conflict, the fact that we are representing their wish to be reunited when there had been disclosed that they have been sexually abused for about since their mother died. But in terms of representing what they want, which is to be reunited, one thing that we are as counsel for the children look at is the fact that they describe their relationship with their dad as a good one, and also that from the information obtained from the school staff and everybody else, they describe the children as happy and that they have been working in they have been functioning well in the community. They are honor students, and they don't see this as if they were threatened by their father to do this. So that might be, they still have a good possibility.
And are you, again, Jason and Alicia's attorneys, are you bound ethically or by any, any rules in the Commonwealth to represent your clients the way that you do? In fact, it's a client-directed model that you're proposing to this court.
I'm confused because they're minors, so are we advocating for what
I'm asking
minor
you.
wants?
I'm asking you. You're not asking me.
That's
I'm asking you.
I know. I don't see how to get the answer.
This is a tough one.
Well, best interest might be not what the kid wants, but that's what the best interest is for them to get out of the house at that moment.
I need to say that although my job is to advocate for my client has, her wishes have changed. Initially, her wish was I don't want to see my father again, she stated to one investigative reporter, and now she's saying that she
That's
wants
not what
to
she
go
told
back.
you, counsel.
But she has been staying with her father's brother and mother. And, that has to bear on what she's saying now. These kids...
The court should, that's a legitimate position, but not from Children's Counsel. The court should be hearing that from someone else, and that was the GAL.
They're staying with his relatives.
But that's not your position.
I
Again,
know, but I'm looking up.
and in fact, and I quite understand. On its face, it looks like such an unfavorable strategy that Children's Counsel are taking. And I realize it's not on the reading for today, but it did have a lot to do with this case. So if you could read those articles, for next Tuesday. In fact, we are in Massachusetts a client-directed model for counsel who represent children will always, both ethically and according to the Committee for Public Counsel as well, must represent their wishes, again, if they can articulate. And Maria used the facts quite well when she commented on their age, how they do well in school, how they've directed. Alicia and Jason have, like adults, that's why the word's client-directed. They've directed the course of their representation. But even in cases, for example, Jonathan is an infant, in cases where the client, due to immaturity or other reasons, can't articulate to you his wants or wishes, etc. Even in that case, you can't be the GAL. You can't be the champion. You can't say, you know what, I think it's best for Jonathan to be pulled out. What you can say, Abby's not here, and she, I don't know if she had a baby yet.
Next week.
What?
Next week.
Next week. So what you can say, though, is that, again, with the clients that like little Jonathan, that can't tell you this is what I want, you can substitute your judgment and you can say that, you know what, if Jonathan was old enough and mature enough, he might want to be free from being sexually abused. That might be his position, and it would be perfectly okay for Jonathan's attorney to take a separate position from Alicia and Jason's. But because of their age, because they were mature and whatnot, and in spite of the fact that they're living with Uncle Tony, and that was a huge issue, but not for the children's attorneys to bring up, not when the children are saying, because when you, and think of it, the most logical way that I can think of it, even in the horrendous cases like this, is that if the children's attorneys were in fact representing their best interests and not their wishes, the judge would never ever hear what their wishes are. As outlandish, as unfavorable as they might be, the court would never hear that. And that's when we talk about the voice of children. It means the bad as well as the good. So that's the whole role of counsel thing. I want to come back, though, to the evidentiary problems in the case.
Just quick, when you have a case like this, if you're counsel for the kids, if you're fortunate enough to have
a GAL,
then it's much easier for you to represent, because that's what happened in cases for me, where I have attorneys, right, that are saying what their children clients want, and they know I'm going to talk about what's best for that kid.
Exactly.
And it makes it so much easier for them to do their job. And I think it is better for the court, because the court then gets all of that information, the whole picture.
So the investigator, again, recommended things. You recommended like counseling and whatnot.
Counseling for the father individually and the children together as a group and individually.
As well.
So here's the problem. If there's going to be some sort of settlement here, wouldn't counseling of your client, Lee, involve, in a way, some sort of admission? And then in terms of the Commonwealth getting a hold of that information, especially when the Commonwealth hasn't indicted him yet, or even if the Commonwealth had indicted him, they're still going to get that information. There's a huge sort of problem there, because you know how you try to reconcile and balance the two cases and still come up with a possible family reunification.
Well, we've certainly advised our client not to speak of any potential sexual abuse issues. However, he's very willing to attend therapy, and there are certainly issues that can be addressed to improve this family's functioning in terms of, the loss of the wife and mother and the effects on the family and his medical condition. Certainly can see.
So you're saying you'd agree to therapy, but only as long as it only deals with issues revolving around
parenting,
anything other than
parenting and family integrity. Absolutely.
What is the? I know the department has something to say. What about the DAs? What would you offer, if anything?
We'll just give him 3 years of prison time.
You offer 3 years?
He said 3 years prison.
What's that?
What did he say? 2 years?
He said 3.
Prison.
We'll do 2.5 if he wants to go to the House of Corrections.
Would you offer a suspended sentence? Suppose that you did, and here's the thing, if they offered a suspended sentence and he agrees to that before the care and protection trial, now the department has, under Jennifer, you know, the ability to bring that in as evidence as well.
He would not agree with that.
So everything sort of has to be decided sort of at once. Geneva?
And we're still gonna argue that, if he withholds from therapy certain pertinent information regarding sexual abuse, that he's not fully completing our service plan.
Okay. That's a valid point.
However,
However?
you would never discover that because therapy is privileged and that whatever is said in the therapy would not be accessible to the court.
But I think what Geneva's bringing up has to do with specific providers under the service plan. So for example, it might be like a batterers or some type of group that even if the specifics aren't divulged, we still know that Lee's going to this particular therapy session that identifies.
Rapist
as
Anonymous.
Yeah, yeah.
Well, and there was a case,
What did you say?
I said Rapist Anonymous.
Oh, Rapist Anonymous.
Well, first of all, a therapist would have to report if there was a report of child sexual abuse.
Okay, so we have that, the mandated reporter issue as well.
Right,
Yeah,
so the privilege would not be absolute for our client, and of course, you know, we cannot recommend, in fact, have to strongly advise because his liberty interests are at stake for him. And there was a case on point about where, you know, it was the mother, the court was not looking for the mother to admit that her boyfriend, her husband, had sexually abused the children, but that, you know, it was that she was making progress. And ensuring the protection of the children, which obviously our client would protect his children.
So let me throw this out to, and specifically to Lee, can Lee's attorneys really sort of push the issue here as to both of these state agencies? Because there are so many evidentiary holes in both of the cases and different burdens of proof that it looks like if either case goes to trial, the state may not win. The state might not be able to prove clear and convincing evidence of unfitness. The Commonwealth may not be able to prove beyond a reasonable doubt the crimes of sexual abuse against the children. So can anybody think of any possible settlement short of trial of either of the cases? Karen?
Can we continue it without finding?
The criminal?
The criminal, and then reassess it after 6 months? I mean, isn't that?
They would love that, wouldn't they?
Well, if
No?
we really feel
Don't like that either?
No.
But there's no reason, I mean, you know, we don't think that there's a case at trial, so why would we continue without a finding?
Geneva?
I think there is a huge case at trial, because I think not only do they have all the information they can use from Justin, even though he's not available, that means that all of his can come in under the unavailability exception.
That may be so, but is it going to rise to the level of, especially for the criminal, beyond a reasonable doubt?
Yeah, because I think
with
they're gonna-
out-of-court statements.
I think they're
That's
gonna
all.
end
That's
up-
all the
I
DAs
think-
have.
I think yes.
Who's going to
because
testify?
Now they can bring in the stuff from their children if they get doctor's reports that if they have physical exams that can prove.
There's no evidence.
They have that.
But
They have
We do
that.
have, we do
No
have
evidence.
his statements though, and we should be able to get some conviction, even if it's not for what we want, on his own statements. So,
What, a decent exposure?
Maybe
How
that's
much is
that.
that?
The only evidence, the only thing he admitted to was having his kids
Good makeup.
take their pants off and stand in front of
we
him
can
as
still probably,
punishment.
we can probably still get 1 year on that.
We
For
can
what?
still get Justin's, Justin's statements and
But that's gonna be dismissed.
What about
because
his
it's not
diabetes?
a-
Can we hold for a second? How do they have no evidence? How do they not have evidence that a 12-year-old had sex? You can prove that a child has had sex.
You can?
Only
No,
medical
I
evidence.
got that report.
I gave you a piece of the doctor's
Yeah, you
report.
have
There was
that.
nothing.
There was nothing.
No physical evidence, Geneva.
Right, so she didn't have sex.
There was
Right.
no physical evidence.
Everyone's assuming he did something.
Physical exam, whether
The assumption is that everyone's assuming that this guy molested his children.
Right.
She hasn't got her period.
What we
Wait,
have
shh,
is,
Ed, go ahead.
we have different statements and contradicting statements of what this guy actually did.
Yes, we do.
He admits to taking down the children's pants.
Yeah, yeah.
It upset him.
Yeah.
He considers that
Yeah.
abuse.
Yeah.
That's really
The
what we
children
have.
say that as well to the investigator,
They do.
right?
They've changed their stories.
Yeah.
They were talking to, Jason spoke to the social worker alone,
Right, right.
somewhat leading with the dolls.
Yeah.
So
Oh, Amy, I'm gonna let Amy come back to that, go ahead.
So I think we're jumping to the assumption that he actually did commit these crimes.
Okay.
Yeah,
Amy,
there
you
is-
started at the beginning with the leading questions.
Yeah, I mean, the kids never came right out and said everything. I mean, even with the dolls themselves, the anatomical dolls, when she gave them to Alicia, Alicia did nothing with the dolls. The social worker picked the doll up
Right.
and put the doll
Yeah.
in a position and said, "Is this the right?" Now, you've got a child that is sitting here, you know, you've got a social worker that's saying the child is immature and she's giggling about using the word penis or vagina and all this. You got a police officer's report who's saying that she was very clear and very mature and able to say exactly what happened, how it ended, the whole bit. And you've got a child saying yes, because she's, at this point, she's embarrassed about the conversation and is, in theory, naive about what's going on. You've got Lee, on the other hand, over here saying, hey, look, my kids are fighting, the kid, you know, a daughter walks in on the kid while he's in the shower, they get mad at each other. I had no idea what to do. He's lost his wife, he's lost his brother who committed suicide, who after a serious injury, he has a serious injury now, he's losing his sight, he's losing his career, he's disarming bombs. I mean, this guy has more stress on his shoulders than he knows what to do with. So now he's a single parent after a traumatic loss and violent loss of his wife. And now he's sitting here trying to say, I don't know what the hell to do with my kids. My kids are fighting because they walked in on each other. All right, guys, strip. Now you see each other. Now there's nothing to get mad about. You know, get over it. But he knew it was wrong, and he comes back and says, I know I was wrong. And to him, having the sexual abuse history of his own, he came back and said, look, I know I was wrong, but I didn't know what else to do. So I think if you're going to give him some kind of help him be a single parent. Help him get what he needs. Help make sure he's got his medical attention. Make sure that he's got,
that's
you know,
what the investigation
advice on how to handle some of the, you know, give him some parenting lessons and maybe someone that comes in and helps him.
Okay, now let have the department last word. Last
I
word.
saw it. I just
Both your hands were up.
I was gonna say, you've got 3 children saying pretty much the exact same story.
No,
So,
they
yeah, they all
Let the department have their word. Go ahead.
in the police report and in Ellen's report and the investigator's report, they all said the same thing, that Alicia and Jason and Justin have reported that the father would lay naked on the bed and force them to do things, and that Justin watched and Jason did stuff and Alicia did stuff. So I think there is enough evidence to go forward.
Okay, you want to continue Tuesday?
Question about Tuesday then, are we doing?
Wait, stop for 1 second.
On the syllabus then,
Yeah.
are we doing what was originally for today, the 23rd, is that Tuesday? We're
The
doing-
medical neglect?
Role of counsel.
Yes, read roll of counsel, because I already brought up those issues in the context of this.
And then will we?
Medical neglect
Will be on Thursday.
on
that's the next
Thursday,
one.
yeah.
Okay.
The mental health, I usually always have a speaker, and I don't know when and if I'm getting him anyway, so we'll sort of be on target after that, okay? And I'll give you on Tuesday the IFA case, the role playing.
Right.